Okay. Ready to rock and roll?
I'm ready.
All right. Thank you everyone for joining us. My name is Melissa. I'm the communications director here, and we have Nancy Harrison with us, who's going to host today's family law workshop. I would like to let everyone know that I have you muted. If you have a question, you can pop it in the chat or raise your hand if you're tuning in virtually with the hand raising emoji up at the top. And then when you are going to talk, please unmute yourself. I don't have the ability to do that. So we're going to let Nancy kick it off then.
Okay. Good afternoon. So today we're going to talk about domestic violence. So let me give you a little intro. I'm Nancy. Law, which includes domestic violence. I'm here in conjunction with the St. Johns County Clerk's Office and the St. Johns County Legal Aid Office, where I also assist with their programs. And they are also available if you need help. You can contact their office. There's some flyers in the clerk's office. I also brought some today. Okay, so they're out for you to pick up today, and you can get some assistance through them. That is free. Are serious issues, whether you file them yourselves or there's one filed against you, because domestic violence is serious. And domestic violence comes in many forms. Most of the time we think about them as assault, striking someone. Now we have stalking, we have cyber stalking, there's date violence, injunctions. So there are a variety of those out there. So a lot of people think, well, do I have enough for this injunction? Well, in a domestic violence injunction, if you've been hit by someone, you clearly have a basis to file it. So the basis to get a permanent injunction or even injunction that's extended out beyond the temporary injunction, you have to show that you have some kind of reasonable fear that there is imminent danger to yourself or your children or, whoever you file on behalf of. If you're filing a domestic violence injunction, so just straight up somebody has hit me, I'm injured, I'm in fear of something, they have to be either at the time or in the past at some point, a member of your household. Now that doesn't mean that you're blood related. It could mean that you're friends that were roommates, or it is a spouse. It could be a child who's an adult that live with you, but you have to at some point live together. And the court will ask you about that. The petition says that. You check box. And all these petitions are on flcourts.org. You also have the option to come to the county clerk's office, and they will send you to the appropriate department, which will help you. They fill this out. There's no charge. There's no filing fee for that. There's no service fee for that. The sheriffs serve all of those at no cost. Okay, and there's a reason for that. That's a public policy issue. We want to keep society safe, and we don't want someone to have to pay a fortune to do that. And you can represent yourself, which is why we're here, so that you can learn about those things. I've had someone recently ask me, can, just words be enough for domestic violence? They can be, but they have to be coupled with an apparent ability to do whatever the threat is. So if I say, I'm gonna beat you, can I do that? Probably. Anybody could do that. I might be small, but you can get feisty sometimes, And so if you have that issue and it's very apparent that that individual can follow through with that, then you can file an injunction. Verbal abuse happens all the time, especially in relationships. So as long as it's coupled with the apparent ability to do that act, then you can file. So let's talk about this process. So there's a form out there where you can come here and someone will help you fill it out. You bring it to the clerk's office, and once it's filed, what happens is the judge takes your petition and they look at it. And if on the face of that your petition, they believe there's potentially harm coming to you, they will enter a temporary injunction. You will be notified of that, and whoever you file against will get served with that. Then there'll be a hearing set. The statute requires it's done within 15 days of the entry of a temporary injunction or at the time of filing, because the other option is the judge could not enter the temporary injunction and then set a hearing. If the injunction's not entered and you don't get a hearing date, you can request one. You have to go to the JA, the judicial assistants, and ask for a hearing, but they can set one for you. So if they didn't like your petition, they didn't give you a temporary injunction, no hearing, then you can ask for that. So then you show up at this hearing. Okay, so what do you do when you get to the hearing? First of all, the court's going to look at your petition. The opposing party is going to be there. So how do you prove your case? Sometimes you can prove it just with your mouth. I mean, that's testimony. Then it's going to be what I call a he said, she said. So if you have more evidence, if you have photos of injuries, things like that, text messages where there's threats, cyber stalking can be email, it could be text, it could be social media. So you need to get all that stuff together. When you come to court with evidence, or come to court at all, you are bound, just like an attorney, to know the rules of procedure and to know the evidence rules. And when you bring something to court to be entered by the court, you need 3 copies. You need one for yourself, you need one for the court, and you need one for opposing party. If you don't have that, the judge could say no way. So don't bring your phone with a video on it and expect the court to look at your video, and that's all you have. You need to download it, figure out some way to get it on a thumb drive or something to bring with you. Because the other side has a right to look at it, and the court's not going to allow you to let that person look at it, a 5-minute video, while everybody stands there. Okay. So make sure you have 3 copies of whatever you bring. You're also entitled to bring witnesses. Those witnesses will sit outside until it's their turn to testify, and the bailiff will go out and get them. So sometimes you can bring witnesses that will voluntarily show up. Sometimes you need a subpoena. So here you're back to, I have to act like an attorney. You've got to find the subpoena and serve someone with it. And that may not be free. So to pay, I think the sheriff charges $40 here to serve someone. So you'll have to have it served on them prior to your hearing if you want them to show up. So remember, you've got a short period of time to do that. You can request a continuance if you need it for a witness or something like that, but you're going to have to tell the court exactly why. And it's in the court's discretion whether they give you that continuance or not. If there is a continuance and there's an injunction against you, just know that that injunction is going to stay in place until there's a final. There's no way out of that until there is a final hearing. All right, so let me tell you what happens when you walk in that courtroom. If you've never been involved with a domestic violence case, it's what I call a cattle call. So everybody shows up, everybody comes in the room, petitioners on one side, respondents on the other side. Once the judge comes in, he's going to explain everything to you, how the courtroom works. He'll explain that you can agree to the injunction. So we'll enter the injunction, and that's it. You walk out. Some people who filed them will come in and dismiss them voluntarily. Just let them go. Essentially, at that point, the court will enter a dismissal, and your case is done. But the court calls every single case to find out, is there going to be a dismissal? Is somebody going to agree to this? And if you want to have a hearing, then essentially the court is going to sit you back down until they've finished everyone, going through every single person, every case that's there. And then they'll start the hearing. How long is your hearing going to be? I don't know. But the judge has all day. Potentially he or she may, set you a date and time certain later if they have, 50 cases on the docket that day and there's just no way they're gonna get through. Or they may bring you back another day, domestic violence hearing day. And then you start your case. When you come into this courtroom, you should be dressed appropriately. Okay. You shouldn't come in with shorts and flip-flops. You shouldn't come in half unclothed. This is a serious matter. Okay, you want the judge to look at you like you're there to conduct some business, especially if you're representing yourself. I would never let my client come in dressed inappropriately, but you have to think about that. How is the court going to look at you? I know that sounds horrible, but it is what it is. If you come in your work clothes, that's a little different. Unless what you would wear to work would be inappropriate for court. Okay, so think about that. You go. When the court speaks to you, you listen. You listen to whatever the judge is saying to you. Don't talk over the judge, ever. If the judge starts to speak, you better zip it because it's disrespectful. So you have to follow the rules in the courtroom that the judge sets. So if he tells you to stop, you stop. You listen to whatever's being said. If an objection is made, let's say there is an attorney involved or someone who represents themselves makes an objection, you stop. The judge will make a ruling and then the case will go on, whether he sustains that or overrules it. Okay, so you just really have to pay attention if you're representing yourself. This is, again, very serious business, and you want to get all the evidence in that you can, whether you're the petitioner or the respondent, so the court can make a decision based on the facts. So make notes, make an outline, make sure you have all your exhibits in. You need to do all that. Okay? Come to court organized. If you're not, the court knows. Essentially, you want to tell a story. So when you're filling out your petition, if this kind of behavior has been going on for, let's say, 2 years, you need to put it all in there. Tell the judge what is going on in paper. Put it on the paper. And then when you get there, you have an outline. You can walk through the petition and tell the judge about all the things that have happened. So include everything you can. Okay. A respondent in a domestic violence case, even though it's called a petition that's filed by the petitioner, does not have to file an answer, which you typically would in any other type of proceeding. So you don't have to file an answer. You can if you want. If you want to file a response for the court before your hearing, you can do that. There's nothing that stops you from doing that. I typically don't do it unless something really strange is put into a petition. A lot of people get upset when they look at a petition. Well, this isn't true. I understand that. People put things in all kinds of petitions that may not be true. But the matter is, when you get to court, you better have the proof for it. Okay? Maybe the other side thinks it's a lie, but if you have proof for it, you made the appropriate allegation and now you can back it up. All right. Now, when your case is over, the judge is going to tell you right there on the spot whether he's granting the injunction or not. And you will have to sit in that courtroom and wait until there is dismissal or the injunction, because both parties have to sign for it. That gives the court notice that you know about it. And if it's against you, they want to make sure you have a copy. They want to make sure the petitioner has a copy to protect themselves. When my clients get an injunction, I have them put one in their car, on their person, in their house, at work. Now, the statutes have a new tool, which I loved, and quite honestly, I didn't realize it till earlier this week when I was looking at statutes for a domestic violence case. There is a thing called a hope card. So when you get an injunction, you can come down here to the clerk's office. And if you get this card from them, it has on here, your name, the respondent's name, the respondent's date of birth, where your injunction was entered, so St. Johns County in this case, when it was entered, when it expires, and it has your name on it. So if you don't have that injunction, you can hand this to an officer and they can look it up really quick. Okay, great tool. That's an amazing thing. I'm glad that the state has come up with that. Because what do you do if you don't have it? Police can look it up, but it takes a little long. Now, I want to talk a little bit about domestic violence. If you're a victim of domestic violence, please have a safety plan in place. And that means you know where your birth certificates are for you, your kids, whoever, your social security cards, anything that's important. You have a change of clothes and a bag somewhere for you, your children, whoever. So that if something happens, you can grab that and get out quick and come find your place to file an injunction. And call the police. You know, people who are continuous victims of domestic violence, it's very typical for them not to do anything about it and continue to live in that situation because it is terrifying. And I know the statistics show that if you file something or you threaten to leave, they become more violent. So you have to have your safety plan in place. Figure out where you're going. Don't go somewhere where your spouse or your abuser knows you might go there. Go somewhere else and work that out before something happens. That's hard. When you call the police for an issue like that, they're gonna come. They are entitled to investigate any kind of allegation. Of course, they're gonna do a quick site scene investigation and make a decision on the spot there. If you're the victim, the officers are supposed to give you information about filing injunctions, where you can go to get help. Your domestic violence centers. So if you need someplace to go, you can go there. They give you all that information for a reason. So please read it, please use it. Domestic violence is very serious and people die every year because one, they don't do anything, or two, they don't get the protection they need. And unfortunately, sometimes that happens anyway. You have an injunction. So the world's not safe, but at least you have it and you can protect yourself that way. In addition to entering an injunction, if you have children, if this is, you have children together, the court can look at child support and time sharing. So usually if you get an injunction in place, even if it doesn't have children, most of the time, married people, if children are involved and you didn't even file it on their behalf, the court in a temporary injunction is going to give the victim 100% of the time sharing until you have a final hearing. And that's difficult, you know, if you're the respondent and maybe you didn't do anything or that's your position, now you've been cut off from your children, probably your home, you're out the door until there's a final hearing. But the court at that time can address the time sharing so you see the children and address child support. If there's time sharing and there's an injunction in place after a final hearing, your time sharing might be supervised depending on the circumstances, or you might have a public exchange location. There are new statutes now that exchanges can happen at the sheriff's office or substation because they all have cameras there. You could actually walk inside. Clearly, you're much safer there than you would be at someone's home. And the court's not going to allow that because typically you can't have any contact. You can't go within a certain distance of someone's home, business, jobs, schools, cars. I mean, it's very restricted. So the court will set up ways for you to see your children if it's appropriate. Let's see. So I want to give you the statute numbers you should look at, because these things, if you're going to represent yourself, you need to look at them at a minimum. Okay. So section 741.28 are definitions for domestic violence. So every statute in Florida or chapter has a definition section. So it tells you, we're about to talk about all these things in this chapter, so you need to know what these definitions. So in our definitions in this statute, it tells you what domestic violence is. It's assault, it's aggravated assault, it's battery, it's aggravated battery, it's sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, false imprisonment, or any criminal offense resulting in physical injury or death of a family member or household member by another family or household member. So if you think you end up in one of these categories and you're not sure, Google it. You'll get the statute will come up under Florida legislature, read it. Do you fall in that category? And most of the time, if you're filing a petition for some reason, you're going to fall within that category. Let's see. Now this entire chapter is chapter 71, but I'll warn you, if you pull that up on the legislature, it also addresses marriage. So you're going to have to go down to this 741.28 before the domestic violence statutes actually. Then section 741.30 is going to tell you all about the clerk's powers, your petition, what it's going to include, and actually it basically lays out the petition. So within the actual form, there's lots of check boxes. So these are all things that might indicate that someone is an abuser. For instance, has that person ever threatened you before, harassed you before, stalked you, physically abused you before, attempted to harm you or anyone else in your family or anyone close to you? Have they threatened to conceal, kidnap, or harm a child? Have they intentionally injured a pet, an animal of some nature? That's very indicative. Have they used or threatened to use any weapons against you? Guns, knives, anything? Physically restrained you from leaving the house or calling the police? That's typical as well. If they have a criminal history that involves violence or threats of violence, if they've had another injunction against them, whether it was you or someone else, that is important. And you'll have to, if you know it, put down that case number if you know it. Have they destroyed personal property? Have they engaged in a pattern of abuse? So this is also important why you include everything that's ever happened in the relationship. And if they engaged in any other conduct that would indicate they're dangerous people. So there's lots of check marks. So go through it very carefully. Make sure you check all the things that are appropriate to your case. And then you're going to have a place where you can write out whatever's happened to you. If you need an extra sheet of paper, attach it. I mean, if you have to have 12 sheets of paper, attach it to your petition. Because to me, more is better than not enough this situation. There's also check marks if you have children together, if you want the court to address child support, if you want the court to address timeshare, you have to mark those boxes. And then you will sign that everything you said is true and accurate. So make sure it is true and accurate. Now, if you have an injunction that says the respondent cannot contact you, even a temporary injunction, and then you contact the respondent, don't do that. I mean, they're not supposed to contact you back but I mean, it's almost a setup. So don't do that. If you're scared of them, you shouldn't be communicating. So don't do it. And if they violate an injunction, you need to let the court know. They will get in touch with the state attorneys and they may become involved. Then it becomes not just a civil issue, which is what a domestic violence injunction is. It then becomes a criminal issue. And they can be arrested for a violation of an injunction. So keep that in mind. That's why I want you to keep all the paperwork with you. Get a HOPE card, make sure that's with you. This was also something I learned this week, I guess I should read these statutes more often, but if you're employed and you're seeking an injunction, this was interesting. You can have up to 3 working days of leave to deal with the injunction. Now, they may not pay you, but you have a right to it and they can't fire you for it. So keep that in mind if you need the time. They wouldn't have to be consecutive. And only within a 12-month period. So let's see, that's section 741.313. It's interesting. And then if you want, before you leave today, I have all the statutes that define all these different kinds of assault, stalking. I'll be glad to let you write all those down. But let's see. What is going to expect. Now, if you have any pending other cases, you need to let the court know. So when you file this injunction, if you have a divorce going or a paternity action that involves the same people, even a child support case, you need to file what's called a notice of related cases so that the court knows not only do you have this injunction, you have a divorce going or a paternity action going. Because ultimately, in the end, if your family law case essentially dissolves an injunction, then it rules your family law case. Now, if you have a family law case and you don't want that to happen, you need to make sure that it's in there and the other case stays in place. Right, just keep that in mind if you're representing yourself in a family law case and you come to some kind of. Let's see. If you have left, let's say, a marital home because of the domestic violence, you don't have to tell the court where you live. It's confidential enough. So you'll see in the paperwork, it's asking for an address. You can write in confidential because clearly we don't want the respondent to know where you're at. Okay. So remember that part. If you need an interpreter, you can either let the JA know or look at the circuit, the 7th Judicial Circuit's website, and there's a place where you can contact someone and get an interpreter for court because you'll need it. If you don't speak English well, you need to get that. I talked a little bit last week about evidence code, and it's a lot. It would take months for me to go through all of that. So I do have a cheat sheet for evidence issues. So if someone if you want to make an objection, you can say objection, but the judge is going to ask you the basis for it. So, I mean, it could be hearsay, could be many things, but if you don't want to read the whole chapter 90, then I have a cheat sheet if you want to grab one today before you leave, or you can give me an email. Let's see. All right. Now, I want to go back to some basics. I want to remind you that the clerk's office here and the staff here cannot give you legal advice. And I know that's frustrating. You walk in, you think, I need to fill this out. They can tell you procedurally how this will work, but they cannot give you legal advice. So does everyone need a lawyer to handle a case themselves? Not necessarily. I would always recommend that you maybe have a consult and get some information, but you don't have to do that, which is why we have these workshops, so that people can learn how to represent themselves appropriately and prevail in their cases, or at least get all the facts to the court. Because the court, in making a ruling, has a lot of discretion. Okay, they are unbiased people. They come into the courtroom, they don't know anything about your case other than what's on paper. And then they expect you to present your case. So that's why it's so important to give all the testimony you want to give, get all the evidence in that you can, and let the court make the decision. Are you always going to be happy with the decision? No, you're not. I leave court sometimes, I'm not happy. But that's it. I gave them the facts, court makes the decision, applies the law, and makes the decision. Can you do anything about it? Sure, you can file an appeal, which is even more complicated than representing yourself in a court, a circuit court. All right, I told you that you have to know the rules of the procedure and you have to know the evidence code, just like you were an attorney. Now, what happens if you don't show up in court? Let's say you file a petition and you don't show up for your hearing. Judge can dismiss your case. That's it. You're done. You don't want that to happen. Now, if you're a respondent and you've been served and you don't show up in court, then the court can enter the injunction. There essentially won't be a hearing. Judge will just go, okay, well, here you go. You can have it. It's freebie. You don't have to present any evidence. Okay. If you show up to court and the respondent has not been served yet, they will continue the case to the next time they have hearings until that person is served. When you come to court, we talked about clothing, we talked about judge and listening. Do not bring children. Okay. Children are not allowed in a courtroom, even if it's a child that's harmed from the violence. You have to get the court's permission, if they're a minor, to bring them to the court. So at that first hearing you go to, you need to tell the court, this is against my child, you know, they're 10, can I bring him or her, and how that works with a judge generally is the judge will have a private conversation with that child because it eliminates two parents being there typically. You know, potentially another attorney. It's unfair to a child. Children don't want to pit their parents against each other, even if they've been harmed. So that's how the court normally does it. And that's a traumatic thing to sit in a courtroom and testify about what someone's done to you in front, remember, in front of everyone who's in that courtroom, which could be, you know, 50 to 100 people. That's not fair to a kid either. So don't bring them. When you're testifying, you are talking to the judge. So look at the judge. The judge is watching you. People who don't look people eye to eye typically are not telling the truth. And the judge knows that. So you are telling your story to the judge. You are not to argue with opposing party. Okay? You're not telling them the story. You're telling the court the story. So if it's the respondent's turn to testify, unless you're making an objection as a petitioner, you don't interrupt that person. Okay? They get to tell their story too, even though you may not like that. You may not like what they're saying. An objection is not their lying. That doesn't work. That's not an appropriate objection. Now you need to come back and ask questions of the respondent to try to turn that around. So if you said that you did so-and-so, then why blah, blah, blah. I mean, you can turn that around if they're not telling the truth and you know the facts. But don't interrupt that person unless you have a true objection. Stay focused on your issues. I have to prep my clients to appear in court. I teach them how to testify. I have a 3-page document that tells them how to testify, which starts with tell the truth, because if you don't tell the truth, at some point, you're gonna get wrapped up in your web of lies and it's gonna come out. Listen to questions. If you don't understand a question that opposing party or another attorney is asking you, say so. If you don't say so, who knows what you're answering if you don't know what's being asked of you? Even if it's the judge asking you a question, if you don't understand it, say, I don't really understand what you're asking. Could you ask me again or another way? And they will. But make sure you don't do that. And then I have clients, and this is just an example. I'll say, so what's the temperature outside today? Well, it's 98 degrees. And then they go on to tell me what the ocean's like, what the sky looks like. So don't do that. Okay, you were there on your petition. You've laid out your allegations. Stick to that. Okay, don't stray off from that because the judge doesn't want to hear it. And quite honestly, nobody in that courtroom has time for it. Stick to your facts, show the facts, and be done. And last, be prepared, always. Don't walk in there with all your paperwork like this, your exhibits aren't organized. You're trying to get an exhibit out, you're having to dig through 100 pieces of paper to get one thing out. They need to be in order, the way you want to present them. Look at your petition. What evidence goes with your story? Put them in order, so when it's time to give it to, you hand one, well, and you're gonna hand them to the bailiff, and the bailiff will pass them out. But give one to the judge, opposing party, keep one for yourself, because you need to know what they're looking at as you're asking them questions. So be very organized. If you need the cheat sheet for the evidence stuff, read it before you get there. Don't try to look at it on the spur of the moment and come up with some kind of objection. You need to figure out what these things mean and how they would apply. And then you can pull it out at the hearing and go, here's my objection. But you need to say it immediately. So if someone says, so what did, let's say, John, your child, tell you? Okay, that's hearsay. You have to make the objection. You have to say objection to hearsay. So if it's the appropriate objection, the next thing the judge is going to say is ask of the other person, what's your response? Because the child saying something to another person is hearsay. The only thing that happens in court, typically, that is hearsay that's admissible, easy kind of hearsay that's admissible, because there's lots of hearsay that is admissible and falls into an exception, is what the respondent says that a petitioner says the respondent outside of court. It's hearsay, but it's an exception because you're parties. So it's really an admission by someone. So I would suggest you pick up, if you have a case that's coming, pick up the evidence cheat sheet I have and look at it, read it. You may have to look up definitions of words. What does that mean exactly? But be prepared, and that's part of it. I think I've covered my material. Does anybody have any questions? I could ramble for an hour, but yes.
I'm curious when that Hope card,
Yesterday.
really?
Yeah, that's awesome.
I had no idea.
It was launched yesterday. I can give you some more information
I
after.
love that.
Yeah, I didn't look and see when the statute started, but it is very new.
It went into effect yesterday.
Did it?
State, or
Yes.
just for this, like, that
The whole state. It's an actual statute. So it's in play now.
I like,
I do too.
I want to say they announced it about a month or two ago, kind of gearing up for it, and then it was just put into effect yesterday.
I love it.
Very nice.
Thank you.
So if they get an injunction in the courtroom today, can they bring it down here and get this
I want to say there's a couple of day waiting period,
until it's in the docket?
within 3 business days after receipt of request. The clerk's office must
Okay.
create the card. Is that timeline correct?
Well, if an injunction, a final is only in place, we go into the, for a final injunction.
Right.
And once the final injunction is in place, yes, if we come the same day, if we have the copy on the docket, we can provide that whole,
And they're also offered digitally.
yes.
Oh,
Well, that's how we're currently doing them all digital.
okay, that's great.
If you have a lifetime injunction against somebody,
Permanent, yeah.
you can just pick it up anytime. then?
Yes, I guess if you have one that's in place already, you can come get one.
Now, the whole part is only, it's effective for 2 years. So every 2 years, if it's a permanent injunction, you will have to come back and request another card.
I'm gonna go about, having somebody served without having their address. My kid's mom, I don't know where she at, and don't say, put in footwork, but you said earlier, don't stalk. I have no criminal history. I worked at my same job for 10 years. I have paperwork, she got in all kinds of trouble, and I got the short end of the shaft years ago. I got sent to an outpatient, I didn't neglect my son. That was the argument in court with the judge, because again, I did nothing.
Is this a domestic violence?
Not at all. Again, I've never been
It's
arrested.
a,
She's the one that has the criminal history. So like, what
so
is
what are
it?
you trying to say?
Everybody is believing lies. That's what's happening. So the good guy, so I'm like lost right now. And I think I'm in the wrong class right now with the domestic violence, but.
Well, we
just
just cover all
referral
that stuff.
And
But what kind of case are you
it
talking
was
about?
dependency. She neglected him. He was a year old at the time. This was 7 years ago. But me and her was getting along, co-parenting, if that's what you want to call it. And what it is she calls all the shots. So if I say, why don't you have this son? Why don't you trim his nails? Why don't you cut his hair? She gets offended. She gets upset. This last time around, she was leaving him alone by himself. And I had a problem with that. I said, why would you do that? And she jerked the rug, and I haven't heard from him, don't know if he's safe in 2 years. And
And there's an open dependency
No,
case?
that's all that's closed. She's been arrested before, so she knows to jump through hoops. I know nothing about that. I can't control myself when someone's saying, you're a bad guy, you did something, and I'm like, absolutely not, I did nothing wrong.
So were y'all married?
No.
Okay.
I met her, she was living at the Debbie Griffin house. Debbie Griffin house, women run there from abusive relationships, but because she had been arrested so many times, that's like, she knew of where to go.
Okay, so this is a child of your relationship. This is your child.
We had a
Have you,
DNA
do you
test.
have any court orders?
The last court hearing and the judge, Alexander, he's no longer here with us, like he's retired, he's
Right.
beyond. I wasn't required, they didn't let me go to the last hearing because they know I would have said it's only a matter of time, Your
What
Honor.
kind of case?
Dependency, when
Okay, so
When
you
they
don't
took the
have
baby from her?
paternity action. You don't have any time sharing with this child.
No, I went down and did the DNA swab, everything came back, we stood in front of the judge and said, I am the dad, I am his father. But again, I did nothing wrong, and she don't have my son enrolled in school. It's so bad, if the courts only knew the mistake that they made many years ago.
Well, then make the court aware, you need to file a paternity action, requesting time sharing. Okay, and then you're gonna have to go through a process to get her served if you don't have an
And
address.
yeah, I don't know where she's living.
Okay, well, there is a way to do that. It's through a publication. But you have to do your due diligence. So you can Google that and it'll tell you how to do that due diligence. And then you provide it to the court. Court will issue this little newspaper article, basically, that gets put in a newspaper, runs for 4 consecutive weeks. Then there's time delay to allow her to respond. And if she doesn't, then the case moves forward. Okay,
So,
even without her being served, like you would normally have sheriff's service. That is an alternative to service. So, yes, you need to do that.
Go to the courts right here.
Yeah, they can give you the forms for paternity action, or you can go to FL.
Fill with the big stack of words about like that.
It's a big
Got them at the house, but I did it.
Fill them out.
Yeah, and then
Or
you
you
hit a
Come
roadblock
to,
with an address, I hit a roadblock with an address.
Let me give you one of these and then afterwards I can
The
give
Kids
you
Bridge.
the phone number.
We went
for-
through Kids Bridge, I don't
Insurance
recommend Kids Bridge with the cameras everywhere. It's good for certain people that are really on stuff, but ones that aren't, then you really realize they're not doing much. I mean, the play area, the ladder that the kids would climb, I noticed there was a rust female sticking through it, ripping kid's head open. But she let me address and fix that. There was like rat droppings on the damn windowsill, but this is a place that you take your child.
Right.
And
I
they say
understand
it's
that,
safe.
but you
And
need
they
to
charge
file
you.
for
If you don't pay,
action.
if you don't pay them $30, you don't see your kid, and it's super emotional that they tear you, you know? Like I said, again, I worked for 10 years down the road at the same spot. You never spend a night in this county jail to be shafted the way I am.
Right.
And it's only because of frustration, guys.
Well,
If I come off like this, they think, oh my gosh.
You
And
need
it's
to
not like that.
file the paternity action, okay, and get yourself some
Yeah,
money.
cause I'm like just going through it. I mean, I can't, like, I wake up in the middle of the night, I know he's not safe. And he's 9 years old and he's not enrolled in school. It's not right.
File your action and then you can learn.
Can I talk to the clerk of court?
Yes, they'll give you all.
Cause I mean, as far as the domestic violence and all that, I'm upset here with you guys.
Right, I got you. Yeah,
And
they'll
if
be able
anything,
to
like,
give you the
she
form.
tried that with Betty Griffin, she tried to, get an injunction and just everything to make me look bad. She's doing everything to make me look bad, and she's the one and it was, I don't know, support, money, and all that other stuff, and I worry about him every day. If you would have read this thing right here, you would have been heartbroken. When I got the police report years ago, the lady said, sir, before you read that, you may want to step down. That's how bad it was.
Right, I
You know,
understand
and I
that.
tried to stress to Alexander and he's like, I don't want to hear you. I don't know, you gotta kind of comply with them, you know?
Make,
They want to hear, hey, I wish you all the best, thank you
thank
guys.
you, you as well.
We had a couple of questions come through the chat. Catherine had an injunction filed against me for a bunch of lies, one of them were these. Sorry, I'm trying to. Can I scroll?
Yeah. Let's start with the first one.
Okay,
All right.
I'll hold it right here for a second.
Is that Ms. Hunt?
Yeah, she's
Okay.
typing again.
Ms. Hunt? She unmuted.
Hi,
Has to
Hello?
unmute her.
can you hear me? Can you hear me?
Ms. Hunt, can you unmute yourself?
Can you hear me?
We cannot hear you. Yeah, we're muted. My apologies, that one's on me. Okay, Catherine, go ahead.
Can you hear me now?
Yes.
All right, so have a question about the injunction. So you have a
Yeah.
temporary or a final judgment injunction against you?
A temporary.
Okay. And so, I mean, I don't understand. You're not allowed to go to a public beach?
Yeah, so my husband up and left me out of the country. He had these people come into our house and steal mine and his belongings, went to the property. Basically, they were best friends of us. Fast forward, tried to get my stuff back. Cops came. Then there was a trespassing thing pressed that was like a warning. But then they tried and filed a restraining order on me. And basically, they've listed, like, I don't care. I don't ever want to talk to these people again. Like, they've got their home address on there, they've got their work, but they've put Jacksonville Beach Pier and Mayport Pools on the order. And the judge, I never got to tell my side of the story because my lawyer agreed. I'm becoming a physical therapist. He agreed that it was better to not risk it and lose in the trial or whatever, when this could be dissolved in 6 months, which is what the temporary order is for. But there's an event outside of like the beaches that I'm worried that they're going to be at, and I'm they're just like coming for me, and I don't know like what to do because I don't want to go to jail. Like they've already tried to put me in jail for this. Like
Well, so my question is gonna be to you, I mean, how important is this event? Is it
I
worth the
can
risk?
I can miss it, but I'm just wondering, is this my reality now where I can't even like be out and I have to worry because they have people, they are actively stalking me and recording me in our community. My lawyer saw the videos and stuff. So I don't know what to do. Like I'm not contacting them at all, but like what, and I've already tried to file a counter order on them, but I didn't realize that you had to have, I didn't know the law that you had to have like two incidences, and I would have worded it better, but like it's
For stalking?
exhausting. Yeah.
What kind of videos are they posting? Videos of you?
They have videos of me walking around town, like that people are sending them, like, and they have contacted, like, just, I don't even know who's, I don't know. It's a lot. I don't know who's recording me. I just seen that they've got, because they're trying to have me, like, now I'm not even going to Jack's Beach because I'm afraid of being within the 500 feet of the pier. So I don't know what to do.
Yeah, I mean, I hate to say this to you, but you have an injunction against you. It's only there in place for 6 months. I would stay away from any location you're not allowed to be within 500 feet,
Yeah.
period. I mean,
Yeah.
I know that's a horrible reality, but it is what it is at this point.
I just like if I'm not in the area, say I'm like in another town or something like St. Augustine and they come up to me, I guess I'm just worried about what could happen. Like could they just lie to the cops and said that I had somebody contact them and try to get me put in jail? Like I don't know.
Well, if they're
Like
approaching you, um, you need to, one, walk away.
yeah.
Um, these are adults, I take it.
Yeah.
Yeah, I would turn on my phone and video as you tell them you're leaving. I don't know
Mhm.
why you approached me, and just turn around and walk away. Then you have something that shows you didn't do anything. But you
Yeah.
have to be calm, cool, and collected when you do that.
Yeah.
So I'm sorry that you're in that situation, but if I were you, I would do everything I could to stay away from places you're not supposed to be close to, have no communication with whoever these people are.
Mhm.
Not even third-party communication. So if you know they know someone, I wouldn't even talk to them.
Yeah.
And then, yeah, I mean, if you see them out, you need to turn around and walk away from them.
Because I was reading the order and it was like just no contact, and but I was confused on like what if we're out in public and we're out at the same place, you know?
Yeah, I mean, like if you're sitting in a restaurant and they walk in, I mean, you probably should get your check. If you don't have your food, I would get it to go and leave. I mean, you had no control over that situation. I'm not sure a judge would hold you in contempt for that, but you need to get out of there as soon as you can.
Okay. And then I was wondering if you had any advice about the divorce that I've filed.
Yeah, let me look at this real quick. Well, that is unfortunate. So you don't have an address for him at all?
No, and then they told me when I went and filed that they would put a ad in the paper in America, and I'm like, well, why is this being done in America? He's not even in this country. Like, if you're gonna put an
Well,
ad, look, I don't know. But they
if you
said
heard
like
me
put an
talking to
ad.
this gentleman that was here in the building, it's an alternative way to serve someone if you don't know an address. So like I was telling him, look up Google, due diligence and serving process. And it will tell you the steps you have to go through. It is a royal pain. But once you have all that, you can go to the court and ask for a publication. I know it makes no sense. They're gonna publish that here in a local paper and you know he's overseas. But
Yeah,
it is what it is. It's how our rules go.
Yeah.
And once that's happened, he's not gonna answer. I presume
Yeah.
it's simplified. You don't own anything together and have no children.
yeah, we don't.
Yeah, so the court will enter, it'll go into default and the court will enter your final judgment. You can get it.
So will I still have so I've already done the newspaper stuff and I'm waiting it out, but will I have to go to court for if he never answers, or will they just like send me a mail? Cause I'm missing days from my internship. I'm graduating in December for going all this court stuff
You
happening.
gone to a case management conference?
No, I haven't.
They haven't scheduled one?
No, I have, they said they were gonna mail me something, so I'm assuming that's the next step, I guess, is the case management.
Okay, you can look on your docket. I assume you have access to that.
Yeah.
And at the top, under where it says whose case it is and all that, there's court hearings.
Mm-hmm.
You can look in there and see if they have a case management set up for you.
Mm-hmm.
If they do, the court could enter a default and a judgment the day you appear. Depending on your judge, those are via Zoom.
Okay.
If it says you have to appear in court, just get in touch with the judicial assistant. And typically a judge is gonna let you appear via Zoom. The court will not enter a final judgment without asking you some statutory questions. They're very simple,
Uh-huh.
but the state requires even the court to ask those questions of you. I mean, they're simple. What's your name? What's your address? Are you married to him? When did you get married? How long have you lived in Florida? Do you have children together?
Mhm.
And that's pretty much it.
Okay.
And so you'll have to answer those basic questions, but you can do that in a case management conference if your publication is run and he's had the time allowed for the answer.
Okay.
If they haven't set the case management, you can contact the JA and ask for that after you know your time has run the publication and then 20 days after that.
Gotcha.
And then you can ask the court, he hasn't responded, can I have my judgment?
Gotcha. Thank you so much.
You're welcome. Oh, yeah.
My ex-wife is not in compliance with our divorce paperwork, so I've got these forms for contempt of court.
Okay.
I just need to know what I'm supposed to do with them, like, I don't have an address, you said I can maybe do the ad in the paper.
Do you have children together?
Yes, that's what she's not.
And you don't have the address?
No, that's why she's not in compliance. I was in prison for 5 years, I just got out of prison.
Okay.
She has not provided me with an address, a phone number. I only know where her mother lives, and that's her last known address. She's no longer there.
And you know she's not living there?
Yeah.
You know where she worked?
No,
She could be back.
She could be back there.
it could be.
She could be anywhere.
I might try the mother's address.
You just serve the papers there.
Try to serve them
They
there.
are certified.
She may not accept service and say she doesn't live there. But that'll give you a start. Otherwise, you're gonna have to do the same process. You're gonna have to do your due diligence and then come to the court for a publication.
Okay, and if that's the route that I go, what happens after that? She doesn't show up to court. And
With children, I mean, that's an issue. She's supposed to know, I mean, there's been no injunction in place before. Okay, so she's supposed to notify you and actually this court if she moves.
right,
And seemingly she hasn't done that.
no, she hasn't
And she
complied with
could
anything.
go through me too, and she has not. I've been refused.
Oh, you're related?
I'm just not.
Oh, okay,
And I
okay.
have been refused. I have not seen the children in 4 years.
Been longer than that. I was in prison 5 years.
Yeah, but she let me see him for a little while.
Any inclination that she lives local?
No, she is in Ocala, there's that, I'm pretty sure. And the guy she's with is very violent. He came across my backseat, grabbed my throat. I didn't know I could.
Because she may be in hiding. Sometimes if you'll call Ocala's, whatever their utility company is, they may tell you.
Okay.
I mean, it's worth a phone call. Sometimes they won't, but every now and then you get some money, they won't. You know, I don't know where my kids are. I think they're down here. Is that where the mother lives as well?
Yes,
Okay,
well, Bellevue, it's South Dakota.
yeah,
So,
I would start there. I know that's frustrating, especially not to children.
and just for clarification, you said if I do go through that route, of having the paper plate, she doesn't show up to court, that then there's nothing really that gets done.
I mean, I guess the court could do something. I'm not sure what they would do.
She's in,
Did she live in Ocala when you got a divorce? She lived here.
no, we lived in Nassau County when we got divorced.
But the divorce is from Marion.
The divorce is from Marion.
Oh, okay. That's a frustrating thing. I mean, it's hard to find someone. I don't know. I don't know the answer to that. I don't know what the judge would do. They have more resources than I do or you do to find out where somebody's at.
Well, if she doesn't comply, then what happens?
Wow, you gotta find her first. I mean, essentially, she's cut you off, you know, as long as you are behaving since you've been out of prison. I mean, you could file a supplemental petition to change that. I assume you didn't get any time, Sherry.
Yes.
You did?
Yes,
Oh,
yes, we have, I'm supposed to have him every other weekend, every Wednesday. She's supposed to meet me halfway, because I was living in Nassau County, she's in Marion County, so part of the divorce paper, she's supposed to meet me
you
halfway.
don't know any mutual friends that might know where she is?
Just her family, and they're not gonna tell me her.
And they won't tell you.
Oh, no, he threatened to kill, he said.
Even her mother.
Her mother won't do it because she's afraid that they'll take the kids away.
She won't be to see my kids.
So here's what you do. You file what you've got, you do your publication, then you serve a subpoena on the mother to appear as a witness. And then you have the judge facing her. If she doesn't show up, you can ask the court to do an order to show cause, which it's an order from the court saying she needs to appear. I mean, essentially, if he wanted to go that far, he could have them picked up. So
I would do whatever it takes.
there's your chance to get the judge to find out where she's at. It's a long way around it, but it is a way around
I don't think she'd let her mom go to jail. I like
it.
that.
And she may show up because you did that. Yeah, but it's a way. It's the long way, but it may be the only way you have.
It seems like it's the only way to go right now.
Yeah. So that'd be a good way to get her. Catch her. Took me a minute to think about it.
All right,
I'm gonna, what you did.
I'm gonna go ahead and end this one.
Okay.
In the virtual. So thank you everyone for attending. We will have our next family law workshop on November 6th. And this will be recorded and available on our social media pages and on our website. So thank you everyone so much. And thank you, Nancy.
Uh-huh,
We'll
you're
see
welcome.
everyone next month.
And me too. Put your